Your Honors, may it please the Court. Morgan Weinstein on behalf of the appellant, and could I reserve 5 minutes, please?
Yes, sir.
Your Honors, this case concerns a summary judgment that was granted, summary judgment being an extraordinary remedy, and the denial of a motion for rehearing following summary judgment having been granted. It's a residential mortgage foreclosure action. Summary judgment was granted as to defendant's non-pleaded affirmative defense, which denied the occurrence of conditions precedent. Plaintiff had asserted that conditions precedent had been waived or had occurred twice in its complaint. The defendant did not interpose an answer.
Assuming we get past the preservation issues, why isn't Coral Ridge the death knell for that argument?
Yes, Your Honor. Coral Ridge discusses the interplay between Rules 1.510 and 1.140B and D.
I see that, but the defense that's being asserted in Coral Ridge, is release. That's not a typical pre-answer motion defense. That's an affirmative defense, just like we're talking about here.
That's true with regard to the way that the facts are asserted in that case. The court doesn't state that it wasn't a failure to state a cause of action terminally because of the defensive release. And the court does state that Rules 1.140B and D are at play with regard to determining whether an answer is required before filing a motion under 1.510. Moreover, Your Honor, even if that's not the case, and even if release would be a defense which could be asserted pre-answer, that doesn't mean that an affirmative defense which does not seek to avoid an allegation raised in the complaint could be asserted that way. The affirmative defense that is being interposed by the defendant in this case, the appellee in this appeal, was under 1.120C of the Florida Rules of Civil Procedure. The plaintiff had pleaded that those events had occurred, that those conditions had occurred, and pursuant to 1.120C, that's all that's required of the plaintiff until the defendant interposes an answer which specifically and particularly denies the occurrence of those events. That didn't happen in this case.
Didn't the motion for summary judgment state with particularity that you had not established that condition precedent?
Your Honor, I would state that it needs to be in the answer because Rule 1.120C
What difference does it make?
Rule 1.120C requires a pleading, not a motion. But
well, Coral Ridge says you can file a motion for summary judgment at any time, and the fact that the Rule 1.510 requires particularity, that seems to suffice and take the place of having to file an answer. So clearly in the amended motion to dismiss, they address the failure to comply with the condition precedent. Are you saying that the bank was not on notice that at the time of the hearing they had to demonstrate that they had complied with that condition precedent?
Your Honor, I would state two things with regard to that. The first is I don't think that the denial, even if it's within the motion, in this case is specific or particular because it says that the bank either failed to provide a notice or that the notice that it provided was insufficient as a matter of law because it did not comply with paragraph 22 of the mortgage. That's not specific or particular. Instead, it's conditional and states one of two things may have occurred. We're not sure which.
I guess the bottom line is, would you agree that the bank failed to file any affidavits in opposition?
Yes, Your Honor. No affidavit in opposition was filed. The motion for rehearing that was filed asserts that that was because of insufficiency of notice with regard to the hearing. There was not a lot of time to get the affidavit turned around once the hearing.
Was there a motion to continue the summary judgment file below?
There was no motion to continue the summary judgment file below. What had occurred, though, Your Honor, is there was a notice of filing of the notices themselves, which would not be sufficient to assert a claim for summary judgment or an entitlement to summary judgment, but do provide a factual scenario where summary judgment may be inappropriate.
But I guess what I'm troubled with is the bank now is taking the position that you were wrong somehow, even though to follow up with the questions, the bank was on notice that that was one of the issues, that they filed an affidavit. There was no opposite affidavit filed, and that's where we find ourselves, and that's what's concerning.
Yes, Your Honor, and that's concerning because of Coral Ridge. There are subsequent cases that have come out, including from Congress Park and a couple of the other cases cited in the initial brief and the reply brief, which discuss the way that summary judgment works with defenses that haven't been pleaded. Those cases state that in a situation where the plaintiff has moved for summary judgment, and the defendant has failed to raise the defense, the defendant cannot defeat summary judgment, which means if we're to interpret Coral Ridge as to mean that a condition precedent need not be asserted in an answer in order to present a summary judgment motion, we're in a situation where it's easier for a defendant to win a summary judgment motion, to have an extraordinary remedy granted in their favor, than it is for them to defeat a motion for summary judgment and prevent the plaintiff from gaining that extraordinary remedy.
Why is that true?
Because, Your Honor, the cases that discuss the way that summary judgment works in terms of the affirmative defense, when the plaintiff has moved for summary judgment, all state that an affidavit is insufficient, that a motion is insufficient, that the answer has to be pleaded first before you can raise the argument in the affidavit.
So, but the difference is just that it's pleaded. The evidentiary burden in either circumstance is the same, correct?
Yes, Your Honor.
Okay, so I don't know why, or I guess I'm not seeing why that policy argument is something that ought to move us. I mean, pleading is a relatively simple thing.
If it's a relatively simple thing, Your Honor, then I would suggest that it should be done, and it could have been done in this case. But the reason that it should be compelling is, in the cases of Congressional Park and the other cases that are cited in our briefs, a plaintiff moved for summary judgment before a defendant had filed an answer, which asserted a particular affirmative defense. The defendant filed an affidavit which asserted that affirmative defense, and the court and the appellate courts all found that it was insufficient of the defendant to merely assert it in the form of an affidavit or an opposition to the summary judgment, and that it needed to be pled. If that's true, and the only difference is that here the defendant is moving for summary judgment, the policy argument should be compelling because it would be easier to defeat a plaintiff's case than to defeat a plaintiff's motion for summary judgment in a world where we interpret the law that way.
Yeah, but the policy really is notice. And you're trying to convince us that the bank was not on notice that this particular defendant was attacking what they allege to be your inability to comply with the condition precedent. And the bank showed up at the hearing with nothing. Your complaint is general as in terms of compliance with the condition precedent. Most foreclosure complaints alleged that a notice of default was served upon the borrower. I'm not saying you had to, but most complaints do allege that. You didn't do that here. You simply made a general allegation that you'd comply with all conditions precedent. Then we have a very specific motion addressing paragraph 22. But your argument is that's not sufficient to put the bank on notice that they need to come to this summary judgment with something.
Your Honor, respectfully, I don't think that from my understanding, the issue is not notice. The issue is, did they plead it, because the pleading is required by the rules. And so, until they have pled it, even if we're on notice, we're not required to respond.
I'm sorry,
Go ahead.
Go ahead.
Well, despite Coral Ridge saying that you do not have to plead it in an answer, you can plead it in a motion for summary judgment.
Your Honor, Accurate Metal says that you have to plead it, and we cite that case. And Accurate Metal Finishing Court versus Carmel states that an affidavit is insufficient and that it has to be raised.
What's the jurisdiction of that decision?
That's the Florida Third District Court of Appeals in 1971.
Does it reference Coral Ridge or attempt to harmonize itself with it?
That decision was prior to Coral Ridge and harmonizes with the subsequent decisions, which all state that the affidavit is insufficient in terms of summary.
I guess the question I've got is we've got a Supreme Court decision that interprets the rule. I'm not sure I see the 1.140 argument here, because if you read the decision, what it says is the requirement in Rule 1.140B that every defense in law or fact be asserted in the responsive pleading is qualified by the caveat if one is required. Yes, Your Honor. When a suit is disposed of, as here, by summary judgment, there is no requirement that a responsive pleading be filed. I mean, it just doesn't seem to me at all ambiguous what the court is saying there. Prior to that, Your Honor, the court references 1.140B and states and discusses motions that may be made by motion prior to the filing of the responsive pleading. My interpretation of that and my reading of that case is that if you have a 1.510 motion for summary judgment prior to the filing of an answer, it can raise a motion that could be raised under Rule 1.140 prior to the filing of a pleading. I also don't think that Coral Ridge imagines a situation in which a defendant may be able to raise a motion for summary judgment premised on a denial of an allegation raised in the complaint.
These are avoidances of allegations raised in the complaint and not denials of same that are being dealt with in cases like...
Is release an avoidance of
Yes,
the
Your Honor.
allegations? And that's what Coral Ridge dealt with?
Yes, Your Honor. And this case deals with a denial of an allegation in the complaint. It's not an avoidance of the complaint. It doesn't state even if all the facts in the complaint are true, we can still win because we have this other argument, we have this other position, which avoids the complaint. Instead, this says the allegations in the complaint are not true. That is by its very nature a factual issue to begin with. But secondly, it would require the denial of that allegation in the complaint. All that we have in this case is a complaint which states, here are the allegations that we're stating are true, and a motion which states you haven't proven your allegations. But we don't have a denial of those allegations upon which the motion may hang itself. So it's not a defense to begin with. It's called a defense even though it's premised on a denial of the complaint allegations that needs to be specific and particular. In this case, we don't have a denial at all, and if we do have a denial based on the motion, it's not specific or particular because it doesn't state that the notice wasn't sent. Instead, it states that the notice wasn't sent, or in the event that it was sent, it didn't include what it needed to include. And the affidavit is likewise conditional.
How about the issue regarding the verification of the complaint? You've raised that issue about whether or not the complaint that your bank filed was in fact verified.
I'm sorry, Your Honor?
Because one of the things that you've indicated that you had a verified complaint,
Yes,
and
Your
that should
Honor.
be sufficient to counteract the summary judgment, that somehow raises issues of fact.
Yes, Your Honor.
I want you just take a minute and to explain your position, because I'm troubled with the argument that you've made, given the verification language of this for this complaint that was filed.
Your Honor, the verification language in this complaint complies with what was Rule 1.110, subsection B, at the time of the Florida Rules of Civil Procedure, and our argument is not that that verification would be sufficient for the plaintiff to sustain a motion for summary judgment, but rather that it at least raises the factual issue of whether the plaintiff's allegations are true, especially in light of the fact of the subsequent notice of filing of both of the letters that are at issue in this action. Regardless of whether or not those letters had an affidavit attached to them at the time of filing, there's a verification of a complaint which says that conditions precedent were complied with and or waived. There's a subsequent filing of a notice which includes both letters which would form the basis of that condition precedent. So we think that that's sufficient at least to defeat the motion for summary judgment. And this again goes back to the point that contested motions for summary judgment really shouldn't usually be granted, and that's Whole v. Talcott, and that's been Florida Supreme Court law since the 1960s. The nature of the dispute in this case is whether that condition precedent had occurred or been waived. There's a notice of filing of the actual letter before the motion for summary judgment is heard.
But you didn't file an affidavit authenticating it before the motion.
That's correct, Your Honor. We did before the motion for rehearing, and we cite Juba in our brief as well.
But in the motion for rehearing, you can't deny that the affidavits you filed on rehearing contain information that the bank had possession of prior to even filing suit.
I'm sorry, Your Honor?
The affidavits that you filed in support of your motion for rehearing is based on information the bank already had prior to filing foreclosure.
Yes, Your Honor, and...
So you should have filed it and opposed the motion initially.
The argument there would simply be that we should have sought a continuance of the motion for summary judgment, I would imagine. And we did file the notice of filing and state at the hearing, we have this notice of filing. The court could have continued it at that point. The court chose not to, and we think that was error.
Well, do you have a motion to continue in the record?
We do not, Your Honor.
See,
Okay.
that's the problem. That's a problem. You're coming in now, and this is to follow up Judge Sleet's question, where everything was going on. The bank is on notice that this is how it's going to proceed. The bank, quite frankly, sat on their hands, did not do anything until the court granted the motion. Suddenly, they woke up, oh dear, we've got to do something about it. File a motion for rehearing, file the appropriate affidavits, file all of that, and now you're coming in and saying, that was wrong. The court should have considered all that. Where, to follow up with Judge Sleet, all that information you had prior to the summary judgment. How do you get around that?
We get around that. Well, first of all, Your Honor, I would point out that we can get around that because summary judgment was only granted as to one of the defendants in this case. So there's a factual issue remaining as to whether the other defendant received the
But
notice.
that's not an issue on appeal.
Yes, it is, Your
Well,
Honor.
the other defendant, from my understanding on the record, that was denied, correct? You're only dealing with that one in this case?
Yes, Your Honor, but the
All right.
denial of the other defendant's motion is important for this appeal because paragraph 15 of the mortgage provides that notice to one of the defendants is notice to all of the defendants, which means that if there's a factual issue remaining that that defendant received notice, there's a factual issue remaining that the appellee received notice as well.
Well, that's interesting too, but isn't the affidavit indicated that she was not even a party to this?
That she was not a party to the mortgage?
Yes,
If she was not a party to the mortgage, she wouldn't have been entitled to a notice anyway.
I understand. These are all arguments the bank could have done at the beginning or at the motion or at the thing, and this is what's troublesome, is that now you're making all of these arguments after the fact, and that's what's concerning me.
Yeah, I guess what is your best case for the proposition that you can fix what is essentially a preservation failure by way of motion for rehearing?
That would be Juba versus Milcius, Your Honor, and that's 59 Southern
I'm
3rd.
sorry, what was that? What was that?
Juba versus Milcius.
The problem with Juba is, as I read it, unless I've got it wrong, it was a per curiam affirmance. The only opinion in the case was a dissent by Judge Shepard.
Yes, Your Honor, and that dissent indicated that where you have a trial court which is presented with an unsworn copy of a record, and the appellant provides an explanation, then the appellant files the sworn copy, the motion for hearing should be granted.
But that's totally different because in Juba, this was an IME under 1.360, which the report is sworn to there. And the attorney was under the delusion that this sworn medical report was sufficient and didn't need to be attached to a sworn affidavit. That's totally different than what your argument or lack of argument was for rehearing.
Yeah, our argument, Your Honor, and I think it's different factually, but I think that it falls under the same legal precept, which is when there's an explanation of why the sworn copy was not filed beforehand, you should be granted a motion for hearing when it's specific to a motion for summary judgment, because summary judgment should not be granted in most cases.
Yeah,
that again goes back
but the argument in Juba was based on there was a sworn report. You didn't have anything sworn to before you submitted the affidavit.
I may be remembering Juba incorrectly then, Your Honor. My recollection of Juba is there was a sworn report after the order was entered, and that there was an unsworn report prior to the report being entered. And that's the situation that we find ourselves with.
No, Rule 360 requires the physician to swear the report.
Yes.
That's totally different.
And you're actually into your rebuttal time if you'd like to reserve that, okay?
Yes, Your Honor.
Thank you, sir. All right, counsel?
May it please the Court. Mark Stopa for the appellee. I think Your Honor's questions on the issue of preservation are perfectly appropriate, and that's what I intended to start out with. The Florida Supreme Court decision in 2010 in Ailes versus Boemi is very clear that a litigant has to make the specific arguments below if they want to raise the arguments in the appellate court. And here, my opponents have nothing showing that they made any arguments at all. They filed no written memo or response to the summary judgment motion, filed no opposing affidavit. They designated no summary judgment evidence as required by the summary judgment rule. There's no transcript of the summary judgment hearing, and they did not recreate the record. But notwithstanding all that, my opponent wants to come before you and try to present their case as if they argued everything below by trying to say in the briefs, well, it's summary judgment, it's de novo review. There's not an exception to the preservation requirements because of the summary judgment hearing. And what I submit my opponents are suggesting to this court is it would create a dangerous precedent for circuit court judges, because what they want you to essentially accept is that a litigant opposing summary judgment can go before the circuit court, argue nothing, say nothing, right? Say nothing, and then go appeal and raise all of the arguments that they didn't raise below. And if that essentially puts circuit court judges in a position of having to dig through the record at a summary judgment hearing to try to find arguments for the party opposing summary judgment that they're not even making out of fear that they might be raised in the appellate court as a basis for reversal.
And I appreciate all that, Mr. Stopa, but let me have you address one issue that counsel raised. He indicated that below the husband's motion was denied. And if in the actual document it indicates that notice to one is notice to all, His argument is that that should be sufficient to defeat that there was an issue of fact, and therefore that's problematic on the face of the order itself. I want you to take a moment to address that.
Okay, sure, Judge. First, I don't think that issue is preserved at all. Okay. Second, I don't think that is an issue before the court that's been raised in the briefs before this court at all. And third, I don't think that argument works at all with respect to the 559715 requirement, because that's a statutory obligation to give notice and is not modified by paragraph 15 of the mortgage that he's referring to that says notice to one is notice to all. So, and fourth, I don't think that when a plaintiff does not prove compliance with a condition precedent as to this defendant, they can't go forward with the case. They didn't comply with the condition precedent to the filing of the suit. It's not like, and I've done this many hundreds of times, it's not like you can dismiss one defendant and say, well, that defendant's out of the case, but we can go forward with the rest of the case. They didn't comply with the condition precedent that applies to everyone, and that was conclusively established. So, Judge, I think my response would be they didn't preserve it. They didn't even appeal on the issue. It's a non-starter argument with respect to 559 because there had to be notice to both, and that so I don't see that issue going anywhere for them at all. So I don't think they get past the preservation issue, which is a point that Your Honor made right at the beginning. The only issue that the only argument they really preserved was with respect to their motion for rehearing, trying to take the position that the lower court abused its discretion in denying rehearing. That is, of course, an abuse of discretion standard of review, and I cited cases in the brief that make clear that there has to be a compelling reason or exigent circumstance for the lower court to have considered an affidavit for the first time on rehearing when it wasn't presented at the initial summary judgment hearing. And what I always find is the beautiful distinction in that line of cases is the case called Darlimple, which says Hurricane Wilma prevented the affidavit from being presented at the initial summary judgment hearing. So that's a circumstance where it was allowed for the first time on rehearing. That's the type of compelling reason or exigent circumstance to consider an affidavit for the first time on rehearing. And the other cases like Best and Lenertz, where there is nothing like that, it's certainly not an abuse of discretion to not consider an affidavit presented for the first time on rehearing. Even when I presented that argument in the answer brief, my opponent presented nothing in the reply trying to show, well, here's our compelling reason, or here's our exigent circumstance, or here's our really good explanation tantamount to Hurricane Wilma for why we didn't present this the first time. Just nothing. So, Judge, Judge, because on the last oral argument I had before you, I encouraged the court to write an opinion on 559715, and you looked at me and you said, I think what Judge Wallace is trying to tell you is that this is not the right case to write a written opinion. That's exactly the same thing here. This is not the right case to write a written opinion, even though I would love for you to look at this and say, you know what, 559 applies and write something like that. I think I'm going to get an opinion on it eventually, but this is just not the right case for it because they didn't preserve any of these issues. I think the court's questions about Coral Ridge are precisely on point. My opponent tries to, as I listen to the argument, tries to make a distinction between, well, that you can move for summary judgment at any time before an answer if it's a defense like release, and I certainly agree that release was an affirmative defense in that Coral Ridge case, but that you shouldn't, based on a condition precedent. There's no legal authority to support that purported distinction, and to me the purported distinction doesn't make sense. Why, if the Florida Supreme Court says you can move for summary judgment at any time, even based on something that would be an affirmative defense that you'd have to plead an answer even before filing the answer, why would the rule be different for denying a condition precedent, which would typically be in an answer just like an affirmative defense would? There's no explanation for that, no legal authority for that at all. I submit that the analysis in Coral Ridge is exactly the same as the analysis you should employ in answering that question, and that is Rule 1.510 says a defendant can move for summary judgment at any time. And the comparisons he was trying to make about, well, when a plaintiff moves for summary judgment and how it's different, and that's just not the point. It's not the standard. And I thought it was telling that the brief even tried to argue that the Florida Supreme Court case in Coral Ridge was void against public policy. When you're having to resort to an argument to a second district panel that a Florida Supreme Court decision that's been in place for 25 years is void against public policy, I think it's pretty clear that's a non-starter position. To the extent that you do get to, let me address a couple other procedural issues. I don't think they argued that their verified complaint created an issue of fact. I don't think that's before the court, but even if it were, this court issued a decision in Ballinger in 2012, a knowledge and belief verification is not summary judgment evidence, and the 4th District followed that in a case called Lindgren in 2014 in a foreclosure context, that a foreclosure complaint that was verified on knowledge and belief is not summary judgment evidence as a matter of law. I also looked at my record again, and my opponent said that the letters were filed before the summary judgment hearing. The record does not reflect that. Even if they had been, an unauthenticated letter is not summary judgment evidence. The case I cite for that all the time is called Hummel out of this court, Hummel. The holding there was actually to grant cert and rule that the circuit court departed from the essential requirements of law by considering an unauthenticated letter for the first at a summary judgment hearing. Now, to the extent that you do get to the merits, I want to talk about 559715 a little bit. I would ask the court to look, in addition to what I put in the brief, my notice of supplemental authority. We now have, in addition to, I have 45 different circuit court judges who...
And we appreciate that, Mr. Silvas. As you know, whether the circuit judges make a certain decision, that perhaps may be interesting, but that's really not...
I understand. I mean, there's obviously a relative lack of authority. So let me start with this court's decision in Gann. Okay, Gann specifically says that Trent, the case that my opponent leads with, is not the law. This court specifically rejected the proposition that, in that case, the bank argued enforcement of a security interest such as a mortgage is not considered the collection of a consumer debt. The exact argument that the bank makes in this case, this court rejected that position and said Trent is not the law based on 2 11th Circuit decisions that came out after Trent. Now, in addition to those 11th Circuit decisions which this court followed, in my supplemental authority, I've shown decisions from the 3rd Circuit, 4th, 6th, and 10th, as well as those 11th. Those are all courts that are one step short of the U.S. Supreme Court. And unlike the cases my opponent cites, which are like one line of dicta from a Middle District of Tampa case that predates those 11th Circuit decisions, those are cases that hold mortgage foreclosure as an action to collect debt. Like you look at that Glazer decision out of the 6th Circuit, it says we hold mortgage foreclosure is debt collection under the FDCPA, and then the decision goes on for pages explaining why that is. The 4th Circuit holds the same thing, a pages-long decision explaining why mortgage foreclosure is an action to collect debt. The Kmart decision out of the 3rd Circuit came out just in April of this year, says the same thing. And that case actually distinguishes between, it actually says that, well, just because a letter was sent, there's no distinction between a letter and a lawsuit. Both of them are actions to collect debt. If you send a letter demanding money, or if you file a mortgage foreclosure lawsuit, that's an action to collect debt. The 10th Circuit decision says that mortgage foreclosure is an action to collect debt, and they distinguish non-judicial foreclosure proceedings in other states. Some of them say some non-judicial foreclosure proceedings may not be debt collection, for instance, where you just post a notice of sale, but obviously foreclosure is judicial proceedings. So mortgage foreclosure, it is debt collection as a matter of law, particularly on a fact pattern like this, where you had a complaint that requested a deficiency, and it was precipitated by a demand for money. And all these...
And that may all well be good, Mr. Stopa. We still don't have any Florida Supreme Court case or any other DCA case that had addressed that issue. You'd agree with that?
I do agree, and that's part of what I'm trying to persuade you, that there's, I have a lot of appeals with this pending right now, so I'm trying to advance the position and show this court why the many judges who've ruled on this issue have ruled correctly. To me, the weight of authority is overwhelmingly in support of our favor, and especially when you look to the federal court decisions, which are interpreting the same question. It's just overwhelming authority. It's the 3rd, 4th, 6th, 10th, and 11th Circuits, and this court's decision in Gann. And what do my opponents present to the contrary? Trent, a Middle District of Tampa decision that this court specifically says is not the law. I think that the case law is just overwhelmingly in our favor on this issue, and I fully expect that you're not going to write a written decision on this, just like you didn't on the last one, but I want to take the opportunity to try to explain why, in the event that you decide to, I think it's really clear that this is an action to collect debt. And then the other question becomes, well, what is the remedy? If they didn't give the notice, what's the remedy under the statute, right? And I think it's clear under the FCCPA you can't sue for a violation of the statute as a consumer, because 55977 authorizes a suit for a violation of other portions of the statute, but not for 559715. So if you can't sue, how do you enforce the plain language of the statute? Well, because we know the legislature doesn't write meaningless provisions, and it's up to the courts to give meaning and effect to every portion of the statute. So when you have a statute that requires a notice be given 30 days before filing a suit, how do you enforce that? The only way to do it is to treat it as a mandatory condition precedent. And that's what the U.S. Supreme Court in the Hallstrom case did in an analogous context where you had a statute that required a notice be given before a suit, a certain number of days before a suit was filed. The U.S. Supreme Court said that is a mandatory condition precedent to suit, even where the term condition precedent was not written into the statute. So I also cited some Florida DCA decisions that do the same thing, including one from this court, where you have a statute that requires a notice be given a certain number of days before a suit is filed. That's treated as a mandatory condition precedent, even where the words condition precedent are not contained in the statute. And I submit in not only in this brief, but in all the other ones I've done, you will never see a case that has a statute that requires a notice be given a certain number of days before filing suit that is not treated as a condition precedent. Yes, there are some other statutes that are conditions precedent where the term condition precedent is in it, but all of the statutes that require a notice be given a certain number of days before a suit is filed, that notice is treated as a mandatory condition precedent. There's no way around Hallstrom, the U.S. Supreme Court case, and the many other decisions on this issue. So to the extent that you get to the merits on this, and I'd love to answer any questions that you may have about that, I think it's clear, and I think that's why I've been so successful on the lower court level. My opponent also mentioned it in the brief. They argued constructive notice by virtue of recording the assignment was somehow constitutes notice. That's clearly not correct, because the statute requires written notice. There's a big distinction in the law between giving written notice to a consumer and giving them constructive notice by the recording of a document. There's a lot of case law about that, so that's not a well-taken position. There's really no dispute about dismissal without prejudice being the proper remedy here upon the granting of a summary judgment. I think that's clear. So I don't see that there is anything before this court where my opponent has given any basis in which this court should reverse. I think that an affirmance without an explanation of PCA is the appropriate result. So that's what I'm requesting today.
Questions?
Unless there are any questions for the court, then that would conclude my argument.
Thank you, Mr. Stone.
Thank you.
And sir, you've got your, actually, I'm going to give you an extra minute of rebuttal because we were questioning you into your rebuttal time. You may proceed.
And Your Honor, I'd like to just touch briefly on the 559.715 argument, not because I think you're going to make a decision about that today, but because I think it interplays with what else is going on here. Opposing counsel cites Gann and tries to say that Gann says that Trent is not good law, when in fact that's not what Gann says. Gann says that a letter preceding a foreclosure may contain debt collection activity and does not state that the foreclosure itself is debt collection. The defendant is here asserting that it is entitled to relief under Gann, which deals with a letter that was sent, and also asserting simultaneously the position that that letter was not sent. This is the same kind of internal inconsistency that is rife in the motion for summary judgment itself, which states that the letter was not sent, or if the letter was sent, it is insufficient. These are not specific and particular allegations with which the plaintiff can engage. That is why the motion for summary judgment was premature in light of the fact that there wasn't a pleading, and also would have been insufficient under Rule 1.120C, even if you're allowed to raise that argument first in a motion for summary judgment. Now,
but does Rule 1.120C require, or does it limit the denial to a responsive pleading?
Yes, Your Honor.
Show me where.
Rule 1.120C says in pleading the performance or occurrence of a condition precedent, the plaintiff may generally aver. The defendant must raise a denial which is specific and with particularity.
And is there a case?
Yes, Your Honor.
That says that 1.12C must be alleged in a responsive pleading, an answer.
Yes, Your Honor. The case is Custer Medical Center versus United Auto Insurance Company. That's 62 Southern 3rd 1086. It's a Florida Supreme Court case from 2010. It says that the failure to perform a condition precedent is an affirmative defense, and defendants have the burden of pleading and persuasion. It also says that the burden of proving each element of the affirmative defense, that a notice of acceleration was not sent or fails to comply rests on the party that asserts the defense.
Doesn't that undermine your attempt to distinguish Coral Ridge on the basis that it was a denial?
No, Your Honor. Our position would be that it is a denial under 1.120C, but because it is this type of specific denial, which must be raised specifically and with particularity, it also serves as a burden of proof on the defendant and thus qualifies as an affirmative defense. But that doesn't mean that it seeks to avoid allegations in the plaintiff's complaint. And that's the way that the Florida Supreme Court in Custer seems to interpret it, because it says that it's 1.120C denial, which must be raised specifically and with particularity, but also holds that it needs to meet the burdens of an affirmative defense, including pleading and persuasion. Now, if I can turn back to the paragraph 15 analysis, the notice to one is notice to all, that is in the pleadings. We're not required to come to a summary judgment hearing having filed a response. We can take the position that the order is facially invalid because it has a factual impossibility in it, which is that there is an issue of material fact as to whether one defendant received the notice, but there is not an issue of material fact as to whether the other defendant received the notice. That's impossible in a case where notice to one is notice to all, and that is in our briefs, and it makes the order facially invalid. And our argument would be that summary judgment was inappropriate on that ground alone, regardless of any of the analysis under Coral Ridge. Our argument would also be that Accurate Metal and also Turf Express versus Palmer state that you need to plead the affirmative defense. And there's one other case. It's one of the cases that came out after the condition precedent analysis, or after Coral Ridge, and it's American Title Insurance Company versus Carter. That's 670 Southern 2nd, 1115. It's a Florida 5th DCA case, Florida from 1996, subsequent to Coral Ridge, which cites Coral Ridge in holding and still holds that the affirmative defense needs to be pleaded. With that, I'd yield the rest of my time, Your Honors.
All right. Thank you, sir. Thank you both. Appreciate it. Okay. All right. Then the third case that we have, the court is ready to proceed on, is the Pierre Ludovic Duclos-Lasnier versus State of Florida.